Hello everyone, welcome to my online prep. Today we'll start with part 1 of chapter 19, that is employee discipline or discipline management. In this chapter we'll be discussing about the meaning of discipline at workplace, what is discipline management, what are the disciplinary rules in banks and domestic inquiry, how is it conducted. So let us start with the first topic. Any organization which has a group of people have certain defined rules and procedures for conducting its day-to-day business. Some organizations they can call it their standard operating procedures while others can call it their code of conduct. It is the behavior that is expected of all the members of the organization. Here the HR department provides the HR policy, then these rules may be a reference to the behavior while the workers are in the office, they are dealing with the customers, or what is the correct operational procedure, such as in banks where the regulatory provisions they do not allow any kind of deviation. This is just one example because banks are custodians of public money and the general public are reposing utmost faith in the bank. So, in order to sustain the faith being enjoyed by them, the employees have to be true to their values and honest in the deeds as well as their words or actions. In this backdrop, banks need to deal with cases of various indiscipline, derailment, dishonesty. So, in this context, the banks they need necessarily to have in place a proper discipline management system or procedures. There are certain assumptions in employee discipline. First, disciplined behavior is essentially only a voluntary concept. Here, the acceptance of norms or rules should be out of conviction and not of compulsion. This assumption is that the rules and regulations they should be properly communicated to the employees, they should be understood with explanations. What is the main reason behind the rules? Then there are certain norms of expected behavior, they should be described precisely, and the rules should be updated from time to time on the basis of the need that is arising because of the changing scenarios. The authority that is issuing the instruction of good behavior, they should set an example. They should themselves follow these rules. Only then the subordinates would follow. And finally, the employee should be praised in public and reprimanded in private if they do not follow these rules. So, discipline is often compared with a hot stove. In this regard, a theory is given by McGregor. This is known as the hot stove rule. It implies that if the rules and penalties are clear and well understood, then a violation produces some natural consequence. That is, if the employees, members of the organization, all of them have the knowledge about the rules, and then one such person violates them, then there will be natural consequences. Thus, it is same as the burning of fingers that occurs when one touches a hot stove. So, this when we apply in the discipline, then total impartiality while handling the disciplinary matters. There should be no undue time lag in the action and the effect. The consequences should be logical and the punishment for the misbehavior should be made known, and there should be consistency in the managerial follow-up action. That's it. There should not be a large variance. So what emerges from this is that for effective discipline in workplace, it is imperative to have a fair and proper communication of the rules and regulations. What are going to happen in the case of indiscipline? So, positive discipline leads to team spirit, cooperation, mutual respect, high employee morale, and a positive environment. But negative discipline, it refers to that people are being forced to follow the rules. There is threatening with severe punishment if they fail to follow the standards. The correct method should be positive discipline, wherein the members they themselves want to follow these rules and regulations. Next, let us see what is discipline management. It basically involves creating an environment where the employees they voluntarily obey the rules and regulations. They are not forced, but they are themselves willing to follow these rules. It also means including or handling cases of indiscipline or misconduct. There are various approaches to discipline management that we are going to discuss further in this chapter. Trying to maintain discipline only through punitive measures would mean negative discipline, and we have discussed that positive discipline should be adopted. So there are a few steps which should enable the organization to ensure a positive discipline. First, the code of conduct, rules and regulations, they should be laid down clearly with the consequences to the organization in terms of losses and bad reputation. Also, it should be clearly communicated to the workers. That is, what are the result from not conforming to these norms, they should be communicated. The consequences should be clearly spelled out. Then conscious efforts should be made to see that the rules have been easily accepted. The norms and standards should be so that they are easy to adhere to. Setting impossible standards to bound can lead to deviation. Then, once the rules are framed and adherence, they must be insisted upon. Merely just laying down the rules and regulations is not enough. The management or the responsible personnel, they should create an atmosphere for positive discipline. They should notice that the management they are implementing the rules. And finally, the laid down rules need to be modified periodically so that they can ensure that the outdated rules are removed from and the new rules are implied whenever required. Because of the changing scenario, this modification is necessary. Now let us try to understand some of the components of discipline management. First, we have employee counseling, which is a well-established process that ensures compliance to the rules and it leads to more productive employees because it involves advising an employee that can work as a major morale booster. So, counseling is a broad, elaborate process. It includes intent listening by the superior and adopting a positive approach to give the employees right advice to guide them in the correct direction. It should aim to reform the employees by right sizing their attitudes rather than merely punishing them. So, counseling it involves a positive approach. The Whenever it is noticed that an employee has committed an act of misconduct which is of let's say a minor nature, then the counseling process should be helpful. The manager that is looking into the matter will make inquiries, and if it is found that the breach occurred because of poor understanding by the employee, then the immediate attempt will be to explain and educate the employee about the rules that have to be followed by them. Depending upon the kind of misconduct, the level, and the reason put forth by the employee, the counseling process may end by giving necessary advice and taking corrective action in implementation of the rule. So, counseling does not result in inflicting any punishment on the delinquent. It is merely an act of advising as to how the employee they can improve their behavior. Another approach that is followed by the management is reformative theory. This proposes that wherever the level of the misconduct is small or lower level, then the employee should be given a chance to improve themselves. Where one has to take the view of inflicting punishment, the disciplinary authority decides what kind of punishment will meet the ends of justice, and this is based on the kind of punishment which can be imposed for certain acts. So every misconduct does not inflict the same level of punishment. It will depend on the level of misconduct. Herein, where the employees who indulge themselves in malified or fraudulent acts will not be spared. But if employees they have conducted, they are victims of the circumstances, but otherwise they are very highly devoted, they are devoted towards the assigned task, they are genuine bona fide, then they should be treated leniently. In the case of fraudulent activities, very serious misconduct, the harshest punishment in employment conduct is dismissal. It should be inflicted only as a last resort in very serious cases of proved misconduct such as fraud causing damage to the employer's property, etc. So reformative theory focuses on the level of the misconduct and the punishment. Now, what is the disciplinary process that is followed by the organization? First, the disciplinary authority initiates the disciplinary process, which involves advising the employees in clear terms of the misconduct that is committed by them. Here, a fact-finding process is conducted, which may include a domestic inquiry followed by various degrees of punishment. So, first, the employees are made to realize the mistake. Then a certain punishment is imposed so that they follow the rules in future. The effect of disciplinary process is not limited only to the employees that are concerned, but it also has a deterrent or indirect effect on other employees. Now, because of this punishment, they will know that if they conduct such a misconduct in the future, then similar punishment would be given to them. The process thus includes preliminary inquiries, counseling, verbal reprimand, or even certain cases involves just a warning. So the level on the part of management or the level of punishment that is given, it depends on the level of misconduct. Ideally, the approach should be to correct the employees rather than being too strict or too lenient. In the cases where the misconduct is major, or where the employee has gone through all the previous stages but still they're not improving the behavior, then only disciplinary action may have to be initiated. It may culminate in penal action if the misconduct is proved to be of a large level. So, but to impose any penalty, a detailed procedure may have to be followed as prescribed in the standing orders or in the relevant rules concerned. Next, we have the disciplinary procedure and the principles of natural justice. We have already discussed the process wherein handling the employee misconduct is a critical task. Now, the principles of natural justice are universally accepted set of rules that have survived the test of time. They ensure that the protection of rights of the individual employee is there. It provides a sort of guideline for disciplinary proceedings in all the cases of misconduct, that is that it should be fair play during the disciplinary process, the right form efficiency of charge sheet should be there, then proper communication, then they must act impartially and so on. So the principles of natural justice are given below. First, no man should be a judge in their own cause. No one should be condemned unheard. They should be given a chance to explain their act. The employee proceeded against should be clearly informed of the charges that are leveled against her or him. The witnesses should be examined in the presence of the employee, who should be given a chance to cross-examine them as well. The employee should be given a chance to examine their own witnesses also. The documents that are relied upon for proving the charge should be given to the employee for inspection, and the punishment to be imposed should be commensurate with the nature of the misconduct. So basically, fair play is the main fact of natural justice, that the employee should be given a chance to explain themselves, and the decision that is taken by the management should not be partial in any manner. Next, let us discuss the disciplinary rules in banks. First, in the case of award staff. So the disciplinary proceedings, they begin with the initial investigation in the reported misconduct. This is under Chapter 19 of the first bipartite settlement of October 19th, 1966. It lays down the procedure for conducting the initial investigation. Herein, these provisions are periodically reviewed from time to time in the successive bipartite settlements. They add more certain misconducts to the list. Let us discuss the procedure. First, by the expression of offense means any offense that involves moral turpitude for the employee and is liable for the conviction and sentence under the provision of law. Second, if the employee is not prosecuted for such an offense, the bank may take steps to proceed against them. So first we need to understand the expression of offense. It is mentioned in the list given in the act. If the employee is then convicted, the bank may dismiss her or him or give them any lesser punishment after complying with the principles of natural justice. So first they need to prove any charge that is given against them. So if the employee is acquitted, it shall still be open for the bank to proceed against her or him departmentally. Herein, a question necessarily is raised that whether criminal proceedings and departmental proceedings can continue simultaneously. It is first necessary to wait for a period for the authorities to proceed against the employee. Then the acts and the omissions on the part of the employee that constitute the gross misconduct and the minor misconduct, they have been specifically listed. They should be seen. If the act comes under the gross misconduct or minor, then on the basis of that the punishment or the decision has to be taken. Then only once that it is decided to take the disciplinary action against the employee, the next steps that are to be followed. First, the employee shall be given a charge sheet. The employee should be explained in clear terms the circumstances that are appearing against her or him. Then the accused shall be given sufficient time to understand. They should understand the explanation given in the charge sheet. If it is decided to conduct the departmental inquiry against the accused, then the person will be given time to prepare the defense and produce any defense or evidence in their favor. The accused employee shall be permitted to appear before the officer that has conducted the inquiry. They can do so to cross-examine. So this opportunity is provided to the accused. He or she shall be permitted to be defended by a representative of a registered trade union, and they would be given a hearing as regards of the nature of the punishment that is proposed. And in awarding the punishment, the authority will take into account the gravity of the misconduct, the previous record, as well as the aggravating circumstances for the employee. So all of these things, if there is any pending inquiry in the past, this will also be taken into consideration. So this is done only after it is final that yes, the employee or the accused has been convicted. However, it is also cases where an inquiry is not to be held. This is if the misconduct is such that even the proved bank does not intend to award punishment of discharge or dismissal, or the employee has made voluntary admission of the misconduct and the employee is charged with a minor misconduct and the punishment proposed to be imposed is warning or censure. So in this case, when there's a minor misconduct or they have admitted to have made the mistake or the bank does not intend to award punishment, then in these cases an inquiry need not be held. So the managing director of the bank shall decide which officer, that is the disciplinary authority, shall be empowered to take the action. It is also the responsibility of the managing director to decide which officer shall act as the appellate authority. The disciplinary authority may conduct the inquiry or appoint another officer as the inquiry officer for conducting for the purpose of an inquiry. So these are the steps or the procedure that are conducted for the disciplinary rules for award staff. Then we have the disciplinary rules for the officers that are encoded under the officer employee conduct regulations that codify the behavior or the conduct that is expected of the employees. The breach of any norms or conduct is treated as a misconduct by the officer. The conduct regulations, they cover certain main points. These are: an officer at all times shall take all possible steps to ensure and protect the interest of the bank. They should discharge the duties with utmost integrity, honesty, and devotion. They shall also make sure to maintain secrecy regarding the affairs of the bank and its constituents. There should be confidentiality. There's a restriction of employment of the members of the family. The officers, they cannot employ their own family members that are enjoying the credit facilities. Then she or he is prohibited from taking outside employment while they are in the service of the bank. There's also a restriction on excessive lending and borrowing by the officer. And if there is any breach of the conduct regulation, then it will be an act of misconduct punishable under the Officer Employee Discipline and appeal regulations. So these are the areas of concern for the officers. Under this, certain important provisions of the discipline and regulations are given. First, we have the penalties that are classified into two categories. Minor penalties are censure, withholding of increments of pay, or without cumulative effect, withholding of promotion. On the other hand, major penalties include reduction to a lower grade or post to a lower stage in the time scale, compulsory retirement, removal from service, which shall not be a disqualification for future employment, dismissal shall ordinarily be a disqualification for future involvement as well. They are also required recovery from pay or such amount as may be due to the officer employee of the whole or the part. So these are the major and the minor penalties. Minor penalties are in the case of small misconducts, major are for the major breaches. So the responsibility is with the managing director or any other authority that is empowered. They may institute or direct the disciplinary authority to institute the proceedings against an officer employee of the bank. The major penalty cannot be imposed unless a departmental inquiry has been conducted. This is also important. Now, where it is proposed to hold an inquiry, the disciplinary authority shall frame the definite and distinct charges on the basis of allegations. These articles of charge together and with the statement of allegation should be presented wherever an inquiry has to be conducted. Then the officer is asked to submit in written statement of defense to the articles, the charges and the statements that are given and as allegations. This has to be done within a stipulated period, so they are given a chance to explain. Then the officer, after this, if the statement of defense is not received or it is found not to be acceptable, then the disciplinary authority may itself hold an inquiry or they can appoint an inquiring authority to conduct it. The disciplinary authority, they may also appoint a presiding or presenting officer, so present on the behalf the case in support of the articles of charge, while the other officer may take assistance of any other officer employee. That is, presenting officer is there to present on his behalf. The officer employee may appeal against an order that is imposing the penalty, an order of suspension to the appellate authority also, and the reviewing authority can call for records within 6 months and they can review the penalty. So these are the procedures that are followed in case of the officers. There are two penalties, two categories, minor and major. The managing director has responsibility, they can conduct the inquiry. In case of major penalty, departmental inquiry has to be conducted. The minor penalty is simpler. Then wherever inquiry is required, the disciplinary authority, they shall frame definite distinct charges. The officer is also given a chance to explain them within a stipulated period, and then further actions are taken. Now, the practice in private sector banks is somewhat different from the public sector banks that we discussed. However, in the case of the old private sector banks, they are members of the IBA, so they follow the bipartite settlement. For the award staff, for example, the rules for officer employees, these are same as the public sector banks. But the disciplinary rules for the officer employee, these are only for the public sector banks. They are not applicable to the private sector banks. So, in the absence of defined rules for disciplinary proceedings, the principles of natural justice will employ in the case of the officers. All these banks, they are in existence for quite some time and they have their own disciplinary rules which are more or less on the same lines of the public sector banks. They are, if they are not following the principles of natural justice, then they will make the inquiry proceedings invalid. There are also other types of banks, namely the new private sector banks that have come into existence during the early 90s. These banks also have their own rules in respect of conduct and behavior, but they are not as exhaustive that we saw in the case of public sector banks. But still, the underlying principle is that they should be fair and they should meet the requirements of the natural justice If the penalty is imposed without following these principles, then they can be declared null by the court if the action is challenged by the accused. So even the private sector banks, they should prepare a proper policy for punishments and justice. Next topic is domestic inquiry. Now, one important thing is that the principle of natural justice also employs to the domestic inquiry. There is, however, a slight difference in the procedure. First, let us see what are the guiding principles for domestic inquiry. First, departmental inquiry is not a mere formality, but it is a serious procedure. Thus, it should be conducted with due seriousness. Domestic inquiry is a quasi-judicial proceeding. Here, the provisions of the Evidence Act 1872 do not apply. Substantive principles of the Act should be kept in view. The scope of domestic inquiry is to determine by the charge sheet or the articles of charge. It lays down the terms for the reference for the inquiry officer. The inquiry officer should not go beyond the terms of charge sheet. So the charge sheet that is prepared or the articles of charge, these are the scope on which the domestic inquiry is conducted. The employee that is proceeded against should be clearly informed of the charges that are leveled against them. Then the entire proceeding should demonstrate a fair play on the part of the inquiry officer. If there are any doubt in the complex matter of what decision or ruling should be given, then it is better to err in favor of the charge sheeted employee. So these are the guiding principles. Proper fair play should be followed when conducting the inquiry. Next, let us see what is the inquiry procedure for domestic inquiry. Inquiry, as we have seen, is a quasi-judicial proceeding. So it is to be conducted with due diligence. In this, the notice of the inquiry, it includes the time, place, and date of the inquiry that should be clearly stated in the notice. A reasonable period should be given to the employee so that they can prepare for the inquiry. Then venue, the place should generally be the unit where the employee is posted, that is the organization. It does not, however, mean that inquiry will be held at the very place where the misconduct took place. Then we have evidence. Any statement that is made in support of the charges must be made in the presence of the charge sheeted employee so that they have an opportunity to question such an statement. This is in regard to fair play. Witness, he is a person who appears in the inquiry either in support of the charge or in support of the CSC. The statements that are made by the witness are considered as oral evidence. Thereafter, cross-examined by the witness of the witness can also be done. Persons who can be present at the inquiry, they are the inquiry officer, the management representative, the CSC, the defense representative, the witness, and the typist who is going to record all the proceedings in the inquiry. Finally, the proceedings. At the first hearing, the inquiry officer should inquire the CSC whether the person has received the charge sheet and has understood the consent thereof. Then, in their presence, further in the inquiry and questioning has to be done. If they plead guilty, the person should be asked whether they have understood the consequences. Then accordingly the decision needs to be taken. After that, both the sides, they have given their evidences and they have also summed up their arguments. The CSC should be asked whether they have anything else to say or submit. Then the inquiry proceedings are closed. So both the sides have to be heard and summed up. Then after the inquiry proceedings are over, there are certain follow-up actions that have to be taken on the logical end. The inquiry officer has to submit the findings, giving the reasons to the disciplinary authority. Then the disciplinary authority either agrees with the findings or they remits the case back, giving reasons for further or fresh inquiry if they are not satisfied. The disciplinary authority in the case of award staff may then propose the punishment and give a hearing to the CSC as to why the proposed punishment should not be imposed on. So they have the power, they have the authority to give a punishment on their own. The CSC may make submission and then the disciplinary authority can take a final view. Thereafter only the order imposing the punishment is passed. If the CSE prefers an appeal against the decision of the disciplinary authority, then the appellate authority should dispose of the case as per the rules and proceedings of natural justice. In case of the officers, there is one more step that is involved in the follow-up action. This is the review. The reviewing authority may call for the record of the case within 6 months of the date of the final order, and then they may pass such orders if they seem fit. They may review to enhance the penalty, and show cause notice will have to be issued. So domestic inquiry, again, it is a quasi judicial proceeding. Due diligence has to be taken. Every concerned authority, they should act in good faith and follow the principles of natural justice. One very important thing in the domestic inquiry is the employee's right to be defended. The model standing orders, also the disciplinary and appeal rule of the organization, they have provided for the right of the delinquent employee to be defended. Here, the inquiry officer has to ensure that the defense representative is no one other than a representative of a registered union or with the permission of the disciplinary authority. They can be a lawyer, the defense representative. They need not necessarily be a representative of the recognized union. If the employee wishes to engage a lawyer, then the matter should be referred to the disciplinary authority, and then further proceedings should be recorded as per the procedure. Where the delinquent employee, they do not have a defense representative, and they would still like herself or himself and the witness examined, then the inquiry officer should formulate the questions in the examination chief and re-examination on behalf of the employee. The cross-examination, that is being conducted by the presenting officer. So if they do not have a defense representative, then also they have the right to be defended. They can conduct the cross-examination. The defense representatives and its role in bank is also clear. The role of the defense representative is to disprove the charges that are leveled against the delinquent employee. They are to defend the employee, they are to prove the charges wrong. To this end, the accused employee will also produce documents and witnesses well in advance and cross-examine the prosecution witnesses. They will also submit a brief to the inquiry officer after going through the prosecution brief. Similarly, as a lawyer may defend their client, the representative is going to defend the accused employee, and they would try to prove the charges wrong. With this, we have come to the end of this lesson. Keep learning with us. Thank you.